79 property was sold to 5,500. The property is bought after 2 years for 3,000. Prior to that, he had left the family and started independent business. He had income of 450 per week.
Item numbers 9 to 12 were sold in the year 15 to 1979.
1979 for 5,500.
Whatever it is, have you not questioned it from 1979?
No, my father died later.
But there is a
Share comes only after that.
when the father died.
This is a suit for partition by
Yes.
the appellant. Suit for partition by the appellant against all her brothers. There was a grant of ex parte injunction of all the scheduled items. Later, defendant 7, the respondent appears and files the written statement saying that in 1979, the property was sold. Items 9 to 12. Property was sold and for 5,500 rupees in 1979. In 1981, only the respondent, out of the 4 brothers, only respondent purchases the property for 3,000. In 1981, Millard, your lordship will see, in 79, property was sold to 5,500. The property is bought after 2 years for 3,000 by one brother. And he claims that he has independent income. But that is disputed.
Age of the plaintiff is 78 years.
Yes. Now, the other brother who has joined in the sale deed has also filed a suit for declaration that these properties, I have produced the plaint also, along with the paper book.
Please come to the order.
Order, Miller.
Yes.
7 to 19. Reasons in page 13. It starts from page 13.
Yes.
Para 10, Miller.
Yes.
The defendant 7 is the only contesting defendant. He too admits in his written statement that initially all the suit scheduled properties. Miller, this is very important. Suit scheduled properties were standing in the name of his father, and however, it is specific contention that Father Nanjaya himself and defendants one and his brother late Shivanna has sold item number 9 to 12 of suit scheduled property in favor of Uchire Gowda on 7/3/1981 from the said Uchire Gowda. According to him, prior to that, he had left the family and started independent business. He had income of 450 per week. With these pleadings, defendant 7 has contended the item 9 to 12 of the suit are in separate properties, and therefore neither plaintiff or other defendants have right. The court accepts this plea and vacates the injunction only insofar as 9 to 12. That your lordship will get it at page 18. Page 18, Miller. The order. The last paragraph.
So now, item numbers 9 to 12 were sold in the year 15 to 1979.
1979 for 5,500.
Whatever it is, have you not questioned it from 1979?
No, my father died later.
But there is a sale deed of 1979.
Correct, my lord. It is a suit for partition. My father died. My right to share comes only after that.
When the father died.
Father, I have produced this. Death 22/1990.
1990. At least, when is this suit?
Suit is of the year 2020.
Hmm.
21.
And some other properties, 7/3/1981 properties were purchased. Item 9 to 12.
Item 9 to 12 are purchased. It was sold to the same person. He sells it back 2,000 rupees less to the family. My lord, the crux of the matter is, I am a daughter of the family. The family was continuing in doing in the joint possession of their property.
Yes.
So, and now that other brother has also filed a suit.
Hmm.
Your lordship will get it in the page 68.
Yes.
The other brother has also filed the suit.
Yes.
And in that suit, he filed for a declaration of partition of the property scheduled 9 to 12.
Yes.
Same properties.
Yes.
And that suit is now listed on 31/8 for evidence. That suit.
Yes.
My suit is not clubbed with it. My lord, dishonorable court. Almost in identical circumstances,
Yes.
has said
Yes.
that there should be no third party rights created against the properties which are where the injunction is vacated.
Hmm.
My prayer is only that.
Hmm.
Let there be no third party rights created, and let both the suits be clubbed and tried.
One Nanjaya is the proposer and he had wife by name Mallamma. They got 6 children by name Basamma, Nanjamma, that is plaintiff, N. Basvaraju, that is defendant number 1, N. Shivanna, that is husband of defendant number 2, and father of defendant numbers 3 to 6, N. Shivarudraya, that is defendant number 7, and Neelima, that is defendant number 8. The plaintiff and the defendant constitute Hindu undivided joint family, and the suit scheduled properties or their family property, joint family properties. Suit scheduled properties are 1 to 11,
Yes.
1 to 11.
12.
1 to 12. The suit is filed by the plaintiff seeking partition. The father of the plaintiff died in the year 1990. According to the defendant number 7, the property that is suit schedule 9 to 12 is sold in the year 1979. And the same was purchased by the defendant in the year 1981. So there are 2 sale deeds. One is of the year 79, the other is of the year 1989, in pertaining to suit schedule 9 to 13 properties. The trial court has observed that the plaintiff is aware of the said sale deeds. Till the suit is filed in 2021, the plaintiff had not taken any steps or not questioned the said sale deeds. Whether the said property that is sold in the year 1979 by the father was not, or whether it is valid or not, whether the subsequent sale of 1981 is valid or not, has to be decided by the court. The fact remains is from the year 1981, the defendant number 7 is holding the property as there is a sale deed in his favor. The trial court had rightly granted injunction restraining the defendants from alienating the property as far as suit schedule 1 to 8 are concerned. But when it comes to 9 to 12, the trial court had rightly rejected the application as there is no prima facie case, balance of convenience and repairable loss in favor of the plaintiff. Hence, this court finds no reasons to interfere. Accordingly dismissed.
Cell number 12 adjourned. 13.